4 days before a Los Angeles jury decided he owed nearly $13 million. Chris Brown was on a stadium stage in front of tens of thousands of people, opening a co-headlining tour with Usher. That's not a coincidence worth dwelling on for shock value. It's a fact worth sitting with, because it tells you something about how two versions of the same man can exist at once. In performing under lights, built for spectacle, the other sitting in a Van Nuys courtroom, while a woman he employed rolled up her sleeve to show a jury what his dog did to her arm. Her name is Maria Avila. On December 12, 2020, she was doing what she'd done many times before at Brown's Tarzana home. She stepped outside to empty a vacuum bag into the trash. What happened next took less time than it will take to read this sentence, and it changed the rest of her life. Start with what the jury actually saw, because that's the part most coverage rushes past. Avila testified in Spanish through an interpreter. At one point, she rolled up her left sleeve and turned toward the jury box so they could examine her forearm, skin raised and pitted where a 200-pound dog had torn it open. Then she removed her glasses and pushed back her hair to show a line of scarring running from beneath her left eye up across her forehead. She told the courtroom she still hasn't been able to look at the photographs of her own injuries. During opening statements, when those images were projected, she had to leave the room. That's not dramatization. That's testimony, recorded in courtroom accounts from Rolling Stone. It matters that it comes first here, because everything else in this story, the legal arguments, the dog's breed, the tour dates, the mistrial, exists in orbit around that single physical fact. A woman's face and arm were permanently altered, and a jury had to decide what that was worth in dollars. They decided it was worth $12.9 million to Avila herself for negligence. Her sister Patricia, who was working alongside her that day and witnessed the attack, was awarded $885,000 for emotional distress. Avila's husband, Oscar Olivo, received $50,000, a legal category called loss of consortium, essentially compensation. Added up, and the number rounds to just under $13 million, owed jointly by Brown and his company, Black Pyramid LLC. Here's where the story needs to zoom out, because the size of that verdict only makes sense once you understand a piece of California law that most people never think about until it lands on their own doorstep. Most states operate under what's informally called the one-bite rule. An owner isn't liable for a dog's aggression unless there's evidence the animal had shown dangerous tendencies before. California doesn't work that way. Its dog bite statute imposes strict liability on owners, regardless of whether the animal had ever bitten anyone previously. You don't have to prove Brown knew Hades was dangerous. You only have to prove Hades caused the injury and that Brown was responsible for the dog. That distinction reframes the entire case. It's why, according to legal reporting from FindLaw, Brown had already admitted negligence in a court filing before the trial even began. The open legal question wasn't whether he was at fault under the statute. It was how much the injuries were worth, and whether his account of warning the housekeepers held up. Now rewind to the dog itself, because Hades is not incidental detail. It's central to how Brown framed his defense. The animal was a Caucasian shepherd, sometimes called a Central Asian ovcharka, a breed developed for guarding livestock and property, capable of weighing well over 200 pounds. Brown's legal team argued Hades was a security animal, not a personal pet, kept on the property according to his own account, because he and his family had received threats. That framing matters legally, because it shifts the story from a man's pet attacked his employee to a working guard animal did what guard animals are bred to do, and the question is whether the humans around it manage that risk responsibly. Avila and her sister's account of that risk management differs sharply from Brown's. On the stand, Brown testified that he had warned both housekeepers about the dogs and told them not to go outside without a security escort. Both women denied that conversation ever took place. Their attorneys pointed out something practical and easy to overlook. Avila and her sister primarily communicate in Spanish, and Brown does not. A detailed safety conversation between them, conducted without an interpreter, was not just disputed. According to their side, it was implausible on its face. This is where the case stops being simply wealthy celebrity, tragic accident, and becomes something more specific. A dispute over who bears responsibility when a warning may or may not have been given, in a language one party may or may not have understood, about an animal capable of this kind of damage. Brown's own testimony about the moments after the attack adds another layer, and it's worth slowing down on because it reveals something about instinct under pressure. He said he was about to shower when he heard Hades growling outside. He ran downstairs and found Avila face down, motionless, with what he described as a significant amount of blood around her. He said the sight left him in shock. He locked up the dog, called out for his security guard, and checked that Avila was still breathing. What he didn't do was call 911 himself. He testified that he left that task to an employee because he worried a recording of his own voice on an emergency call could leak and turn into what he called, in his own words, a kind of media circus. Then, according to trial testimony, he left the property and drove around for hours rather than staying at the scene or going to the hospital. Set that decision next to the phone call Avila's daughter, Yoseline Espinoza, described receiving that day. She testified that her Aunt Patricia called her in a panic, saying her mother couldn't breathe, kept passing out, that the ambulance hadn't arrived yet, and that Brown had already left. Espinoza said she didn't think her mother was going to survive the wait. Espinoza's testimony didn't end with that afternoon. She also spoke about who her mother had been before it and who she'd become since. She described a woman who once took visible pride in her appearance, dressed up, hair done, makeup done, and who now avoids mirrors, avoids crowds, and avoids cameras altogether. According to her daughter, something in her mother's personality itself seemed to have gone quiet. That's not the kind of detail a negligence claim technically requires. Juries don't award damages for a person's spark, but it's the kind of testimony that helps explain why the final number landed where it did. Because the injury the jury was pricing wasn't only visible on Avila's arm. Two decisions made in the same hour, on the same property, by people connected to the same emergency, one shaped by fear of public exposure, the other by fear of losing someone. There's a detour in this story that almost never makes the headlines but changed its timeline by more than a day. Partway through jury selection, one juror admitted to searching for information about the case online and sharing it with others. A serious breach, since jurors are instructed to judge only on evidence presented in the courtroom. Huey Cotton declared a mistrial and brought in an entirely new panel. Several other prospective jurors had already been dismissed earlier for saying Brown's past legal history, his 2009 felony assault conviction involving Rihanna, would make it impossible for them to judge this case fairly. The judge ultimately barred any mention of that conviction from the trial altogether. The jury that eventually delivered the $13 million verdict never heard about it. That's worth pausing on, because it cuts against a common assumption that a jury punished Brown for who he is rather than what happened in 2020. The record suggests the opposite. Extra procedural steps were taken, specifically to prevent that from happening. Whatever influenced this verdict, it wasn't supposed to be his history. It was supposed to be, and by the court's own design mostly was, this dog, this property, and this woman's arm. The financial shape of the case tells its own story too. Before trial, Avila's legal team had sought $90 million in damages. The jury settled on a figure roughly 7 times smaller, still enormous by any ordinary measure, but a reminder that juries don't simply validate whatever number is asked of them. They weigh medical evidence, lost earning capacity, and the credibility of testimony, and they arrive somewhere that reflects their own judgment of what was actually proven, not what was requested. Patricia's attorney, Michael C. Murphy Jr., framed the outcome as vindication after years of litigation, telling reporters the case had taken more than 5 years to reach this point. That timeline is worth noting on its own. An attack that happened in December 2020 didn't produce a jury verdict until the summer of 2026, Nearly 6 years of filings, delays, a mistrial, and a 2-week trial before 12. People finally decided what it was worth. As with most civil judgments of this size, the verdict isn't necessarily final. Brown's legal team retains the option to file post-trial motions or pursue an appeal if they believe legal errors occurred during the proceedings. What was proven, according to testimony, is